Back on the record in the case of the People versus Sherrone Moore. Counsel is present as well as the defendant. And I, first of all, again, want to thank counsel for their well thought out arguments, and most of all for answering the court's questions, which since the filing of the motion for a Frank's hearing and to quash the arrest warrant have been part of this court's this extended thought process. The important thing to the request for an evidentiary hearing pursuant to Frank's is, first thing to realize is that in Frank's, in the Michigan Supreme Court has made it very clear, Frank's, the requirement of an evidentiary hearing and the like, based upon Frank's, is the floor and not the ceiling. Michigan, I think as the people have acknowledged, allows greater leeway and discretion for courts to hold evidentiary hearings regarding issues involving search warrant, arrest warrant, or warrants, where it is in some way demonstrated that there is either evidence which is intentionally or unintentionally, in certain respects, misleading or false, or where there is almost a reckless indifference for the truth. This case brings up sort of a different issue, but brings up the issue of an omission. What is clear from this court's perspective is that an omission in certain contexts can be more damaging, more problematic, more troublesome than what might be an intentional misrepresentation. In either way, or in any event, this court is of the belief that at every proceeding, every representation made to a court should be a full and complete representation to the court so that all the parties can receive their due process. That includes the people, it includes the defendant, and anybody else coming before the court. The defendant wishes this court to have an evidentiary hearing regarding the issues, but fundamentally it's focused around certain portions of the omissions and sort of the context, particularly as I gather from the defendant's argument, and what has been a concern of the court is the context of the relationship. People, on the other hand, don't believe that the court should hold an evidentiary hearing and that it would be an abuse of this court's discretion, which it has, the discretion anyway. But it would be an abuse of that discretion to hold an evidentiary hearing. An abuse of discretion, what is very clear from case law, only occurs where the result of the court's decision or use of its discretion is outside of the range of reasonable outcomes. I don't believe that granting an evidentiary hearing in this case would be outside the realm of reasonable outcomes at all. And just by way of context, in looking at the swear-to by Officer Welker, what's clear, and also from the court's questioning, I think the parties realized where the court was going and should have. The initial part of that swear-to is not set out by the representations of the alleged complainant in this case. It's all set out by her attorney, Ms. Sharp. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things that realize and where the defense is heading is that the context, and I read it as broadly as the defense does, that context to stalking charge, context of that relationship is critical to an assessment of that relationship and whether or not there's this harassing behavior or stalking going on. As I said, I can only imagine, but this court doesn't know, what an executive assistant to a football coach does. I don't know if phone calls or messages might be exchanged all times of the night. I don't know any of that. I can only presume that if they are the executive to effectively a CEO, the range of their responsibilities, duties, communications is vast. But again, I don't necessarily know that, but it's something certainly that the court should have been informed of during the swear-to. It's gone without any rebuttal that the phone calls that were alleged, or alleged to have occurred, occurred during work hours, occurred during those times at which I guess most might think communications would occur. That the written messages, in terms of text, were admittedly employment related, at least is what's been represented to the court. I don't know why that wasn't given to the magistrate. I think that the evidentiary hearing would be necessary because there's no mention of the employment, that context given to the relationship. The context during the swear-to is a one-sided rendition of things by someone else. It isn't, it by no means would constitute a full picture. More importantly, and it may go to the defendant's argument, although they didn't place it this way, I asked what might be particularly false in their statement. That's a tough question to answer, and I appreciate the response that I got. But really, I think that the falsity really comes in the way that it was sworn out. It at worst is false and an outright lie, excuse my language in that regard, or at best it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work-related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incident or later on the 10th, after the issue regarding the complainant's home. Frankly, I think that was intentional. I think it was intentional to place a context without saying it, give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months, you lead that down into all of a sudden this day comes along, or the 8th of December comes along, there are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we now know are not any type of harassment. And then the December 10th incident. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that that was an intentional misdirection to the court in terms of what this should look like. That doesn't mean that I would end up any place different than where the magistrate was, but the magistrate was owed the benefit of having all of that information prior to making that decision. It is in this court's mind a glaring omission to leave out or frame this relationship only in one way. That doesn't mean that it doesn't intertwine itself between the personal and the professional. It doesn't mean a lot of things, but this was not solely this personal relationship, and the magistrate should have been able to look at that and determine what it would be. That you can tell right on the surface. I would suspect as you dig deeper, there would be other issues that aren't painted in their full context in terms of what happened. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in the